Hey, I'm Mike Letson, and I'm currently at the Smyth County Courthouse in Marion, Virginia. If you were driving down Interstate 81 and saw those blue lights flash, you might think you just got a speeding ticket. But if that ticket says reckless driving, you are facing a Class 1 misdemeanor. That means a criminal record that stays with you forever. You don't need that on your record, and today I'm going to walk you through the defense strategies we use right here in Southwest Virginia to fight it. A lot of folks passing through Smyth County, Washington County, or Bristol don't realize that Virginia treats speed very differently than other states. Reckless driving isn't just a traffic infraction where you pay a fine and move on. It is a crime. It is in the same category as a DUI. Because it's a crime, it's going to cause your insurance to go up, and it's also going to go on your criminal record. That can affect security clearances, employment, and your driving privileges. But just because you've been charged doesn't mean you're guilty, and it certainly doesn't mean you have to accept a misdemeanor conviction. We have specific strategies, legal tools, that we use in these local courts to protect your record. The first strategy we look at is what I call the equipment defense. When an officer writes you a ticket for reckless driving based on speed, they are usually relying on a radar or LiDAR device. But in Virginia, the law is very specific about how that evidence is handled. The officer has to prove that their equipment was working properly on the day they stopped you. Under Virginia code, that radar unit must have been calibrated within the last 6 months. If I'm in court in Washington or Smyth County, one of the first things I'm looking for is that calibration certificate. Is the certificate valid? Was it a true calibration, or just a tuning fork test? Did the officer have the certificate with them in court? If they can't produce that document, or if the dates don't line up, the judge cannot accept that speed as evidence beyond a reasonable doubt. If we can knock out the speed evidence, we can often knock out the reckless driving charge entirely. You need an attorney who knows to look for those details, because a judge isn't going to check it for you. Now, sometimes the officer did everything right. They have their paperwork, and the speed is accurate. That is where our second strategy comes in. The mitigation package. This is about showing the judge who you are outside of this one mistake. In jurisdictions like Bristol or Washington County, the judges have a lot of discretion. They can look at your driving history and your character. We often advise our clients to be proactive before court. This might mean taking a DMV-approved driver improvement clinic. It shows you're taking this seriously. Another huge tool is getting your own vehicle's speedometer calibrated. If your speedometer was reading 70 when you were actually going 75, that mechanical error can sometimes be the difference between a criminal conviction and a lesser charge. We can take a calibration to court and show the judge, look, he didn't intend to go that fast. His equipment was faulty. In some tougher cases, especially with higher speeds, we might look at community service. It sounds like a lot of work, but if 20 hours of community service keeps a permanent criminal record off your background check, it is absolutely worth it. We need to keep that off your record. This brings us to the third strategy, and frankly, this is the one we use most often to save people's records. It is a specific Virginia statute, Code 46.2-869, known as improper driving. This is not a criminal charge. It is a traffic infraction. It is the golden ticket for many of our clients. The law basically says that if the judge feels your driving was bad, but not quite criminal in nature, essentially, simple negligence rather than criminal recklessness, they can reduce the charge to improper driving. This is why you need an attorney that's from this area, that has an office in this area. You need to know who the judges are and what the judge's rules are. A judge in the 28th district might view a speed of 85 miles per hour differently than a judge in another district. One judge might reduce that to improper driving just based on a clean record. Another might require driving school. If we can get the charge amended to improper driving, it carries fewer demerit points. It usually doesn't spike your insurance rates as badly. And most importantly, it is not a misdemeanor. It disappears from the criminal side of things. That is our goal. To take a situation that could ruin your background check and turn it into something manageable that you can walk away from. The strategy isn't just about the law books. It's about the people in the courtroom. If you've come down 81 and you're not from here, you might be tempted to just pay the ticket or hire a big firm from Richmond or Northern Virginia. But if you're talking to an attorney and they can't tell you who the judges are in Washington County or Smyth County, or how the prosecutors in Bristol handle reckless driving amendments, then you need to move on to the next. Local knowledge what allows us to pick the right strategy for your specific case. We know which arguments work in front of which judges. Reckless driving in Virginia is serious, but it is defensible. Whether it's attacking the radar calibration, building a mitigation package to show you're a good driver, or fighting for a reduction to improper driving, there are ways to handle this. You don't need a criminal record following you around for the rest of your life just because you were trying to pass a truck on I-81. We handle these cases every single day in Southwest Virginia. If you have questions about your specific ticket or which strategy applies to you, the number is listed below. Please consider giving me a call. I'll talk to you soon.